Welcome to our podcast. Today we're joined by Dr. Triestino Mariniello, hope I said that right, a noted law professor and member of the legal team for Gaza victims at the ICC, to discuss the ICJ's recent ruling on South Africa's case against Israel regarding alleged genocide in Gaza. This historic decision marks a pivotal moment in international law, placing Israel in an unprecedented position. Dr. Mariniello will offer his insights into the legal implications of this ruling, its impact on Israel and Palestine, and the challenges ahead in international law enforcement and compliance. So I'm going to start with the very first question. The International Court of Justice, the ICJ, has recently confirmed its jurisdiction to hear the case brought forward by South Africa. How do you interpret this decision, and what implications might it have for international law and the involved parties?
Well, first of all, many thanks for the invitation today. Just a brief description of the proceedings, of what we are talking about. South Africa brought an application before the International Court of Justice against Israel for alleged violation of the Genocide Convention. In other words, South Africa argued that Israel was engaging in genocidal acts against Palestinians in the Gaza Strip. Genocidal act means a list of acts committed with the intent to exterminate in whole or in part a protected group under the Genocide Convention. Naturally, Israel rejected all the claims submitted by South Africa. At the beginning, Israel decided to be part of these proceedings. That decision could not be taken as granted, to be honest, because Israel does not recognize the role of many international organizations, for instance, the International Criminal Court, which is a different judicial body. But in this case, in light of the gravity of the accusations raised by South Africa against Israel, it accepted to be part, as it is its right under international law, of course. This is a urgent procedure, which means that it takes the priority over all the other cases that are discussed before the International Court of Justice. That's why it took only a few weeks for the judges sitting in The Hague to issue its decision, and it's a decision concerning provisional measures. So it's not a definitive assessment that the genocide has been committed, but it's an assessment done on a lower standard of proof, which is the plausibility that Israel is committing or is going to commit genocide against Palestinians as a protected group in the Gaza Strip. So this is the conclusion of the judges. The judges accepted all the claims by South Africa, concluding that there is a plausible risk that Israel is committing or is going to commit genocide. So a number of acts with the intent to destroy in whole and part Palestinians as a protected group.
Okay, just to break it down, let's talk about the implications. What are the implications of the ICJ accepting South Africa's case under the Genocide Convention?
Well, first of all, there are direct implications because of the nature of the provisional measures. Urgency, as I said before, urgent procedure means issuance of provisional measures. So on one side, the court accepted, and that's why it's historic, the decision, because, as you said before, because for the first time an international judicial institution establishes accountability against Israel. This never happened before. So in the same time, it's not just ascertaining, concluding that there is a plausible risk that Israel is engaged in genocidal acts, but at the same time, as I said, the court accepts some of the provisional measures requested by South Africa. These are the implications. Which are these measures, for instance? Putting an end to all genocidal acts in the Gaza Strip, alleged genocidal acts, preserve all the evidence related to the ongoing commission, alleged ongoing commission of genocide, prosecute alleged responsible of this international crime, in this case of genocide. One of the most important here concept or legal implication is that the court orders, it's not an invitation, it's an order imposed on Israel as a state party, so it's a legal obligation to put immediately an end to all genocidal acts, which are killings of Palestinians, causing serious bodily and mental harm, stopping all those measures that have been put in place by Israel with the intent to destroy Palestinians. Which are these measures? Forced displacement of Palestinians in the Gaza Strip, where, just to remind, almost 2 million of people have been displaced by the Israeli authorities, the destruction, almost complete destruction of the healthcare system, and the list of measures here is really long. The total seizure is explicitly mentioned by the ICJ in this regard, which is the deprivation of Palestinians of essential goods like water, food, electricity, and fuel, which have caused not only deaths but also serious injuries, as again appears in these proceedings. So Israel has a legal obligation to stop all these measures immediately.
So since you have discussed the specific measures, there's one question that keeps on coming up, which is, why did the ICJ not explicitly order a ceasefire?
Well, that's
one of the measures, I mean.
Sure, that's a very interesting question. On one side, I may understand the frustration, disappointment of people in the Gaza Strip not seeing any references to the ceasefire, which, just to be clear, was one of the measures, as you said, requested by South Africa. But reading carefully the decision, even if there is no explicit reference to the word ceasefire, to stopping all military activities, I strongly believe that the court, through all the measures imposed, is, to a certain extent, imposing a ceasefire to Israel. I try to explain it in different words. As I was saying before, the court ordered Israel to stop immediately all those measures, to put an end immediately to all those measures, to those acts that may have a genocidal nature. Killings, causing serious bodily and mental harm, all those measures imposed to destroy, again, the protected groups, forced displacement, destruction of the healthcare system, and so on. So the question here, how is it possible to implement those measures imposed by the court without a ceasefire? How is it possible to stop killings of any Palestinians in the Gaza Strip without a full and permanent ceasefire? How is it possible to stop causing serious bodily and mental harm without a complete and permanent ceasefire? So in other words, the court does not explicitly pronounce that word, but the end of the hostilities is there. Why the court has not pronounced that word? That's from a legal perspective. I think it may be argued or speculated that since Hamas is not a state party, it's not a state, so the court does not really impose any obligation on a state, on a non-state organization. That's why the court has not unilaterally imposed a ceasefire that could depend not only on Israel but on another party. So I think that from a legal perspective is the reason. I've read in these days someone comparing this decision to the situation, to the case Ukraine against Russia, and arguing that there will be double standards in this regard. To be honest, I don't agree that the fact that the court has not spoken explicitly imposed fire shows double standards compared to the situation in Ukraine. For very simple reasons, because the contexts are completely different, and in that case are two states, so both states are bound by any decision taken by the court. In this other context, there is on one side a state, on the other one a non-state organization. So I think that is likely the reason for this. But again, I think it's important to emphasize, sorry if I'm repetitive, but it's important to emphasize that implicitly the ceasefire is there. In other words, the measures imposed by the court imply de facto a ceasefire.
But isn't it taken into consideration that Hamas is actually the de facto ruler of Gaza Strip?
Well, no, this is not an argument that has been taken, into account by the court. At the same time, the court has not taken into account the several claims done by Israel. Most of the submission concern its right to self-defense. I think it's also important to spend a few words on this, because I have read on particular many mainstream media these days, after the issuance of the decision, but also by some Israeli political military leaders, that the court has recognized Israel's right to self-defense. I mean, nothing more false than this, to be honest. Nobody will find any word in the decision, in the ruling of the court on this. The court did not say anything because it was not relevant. Because in any case, self-defense does not justify the commission of genocide. So from an international perspective, this must be very clear. The court in 2004, the same court in the famous advisory opinion on the legality of the war in the West Bank, said explicitly that Israel does not have a right to self-defense against a territory that it occupies. So that's the position of the court. In this decision, the court has not departed from that. So, unless proven otherwise, to be honest, but it's not there. That is the position of the International Court of Justice on the lack of the right to self-defense by Israel against an occupied territory.
Okay, then what are the mechanisms for implementing the ICJ's orders?
Well, that's a really a killer question for an international lawyer, because it's important to stress again that the decision is legally binding under international law. Legally binding means that it creates obligations, legal obligation, not political discretion or political obligation on state. Every state party here has the obligation, even third states, to implement this decision, so to follow strictly, I would say, the decisions, to comply the decision imposed by the International Court of Justice. Okay. However, like most of the international law mechanism, there is no enforcement. I mean, in other words, these institutions do not have enforcement capacity. For instance, the court does not have its own police, as someone wrote, to impose the implementation of the measures, which means that the implementation is political. So first of all are states. How to implement? First of all, states. Every state here, in light of a plausible commission of genocide, has the legal obligation to prevent this violation of international law, which which can be argued it's the most serious violation of international law when we talk of genocide. So every state here, third state, not Israel, not South Africa, not Palestine, has an obligation to prevent. International organizations, which means, of course, UN bodies, including, first of all, the Security Council. The Security Council here has a legal obligation to implement this decision, organizing an immediate session to discuss how to implement the measures imposed. So these are the different ways. And of course, there are also other ways to implement. The court says explicitly that Israel has an obligation to prosecute responsible of genocide as an international crime. So every domestic court under universal jurisdiction, or Israeli here courts, or international tribunals like the International Criminal Court, I would say, have an obligation to go through this case at the criminal responsibility level.
So regarding the provisional orders to prosecute those inciting violence, this is also going to be political implementation, excuse me.
Well, yeah, that's a good question. The implementation of this measure, of course, should be done by domestic authorities. The implementation should come through judicial bodies, so should come through prosecutors and judges, so through domestic courts. The question then is to what extent the Israeli judicial system is independent in order to prosecute individuals who are, as the court said in its decision, senior political and military leaders. I mean, the court explicitly mentioned Gallant, Minister of Defense, and these allegations, these statements. The President of Israel, Herzog, and these statements. What these statements may amount to alleged incitement to genocide. So, of course, the question there is to what extent domestic courts in Israel are willing and able to prosecute Israeli military leaders. From what do we know so far, from what happened until now in the past, well, since in the last 70 years, I mean, it is highly questionable that the Israeli judicial system is willing and able to prosecute any political or military leaders. At least this never happened before. Israeli political and military leaders for international crimes allegedly committed against Palestinians.
So it doesn't matter really if these people, exact same people you've mentioned earlier, have immunity or not, because they're obviously members of the Knesset, for example. So it doesn't matter if they have immunity or not, because
I
have to question if the state is going to do anything about it or not, right?
At the domestic level, it doesn't matter. I mean, at the domestic level, it doesn't matter that they have immunity, because immunity is recognized under international law, and it's as a significant importance under international law to avoid interference from a state into the affairs of another state. So, at the domestic level, the relevance of immunity, I would say, it's void. I mean, that would not play any role. This could be brought before international tribunals like the ICC, or before courts in other countries, like, for instance, most likely will be done in relation to the ongoing case against the Israeli President Herzog in the universal jurisdiction case in Switzerland. Before the International Criminal Court, there is a specific article in the statute of the ICC saying that no immunity, I'm not literally reading it, but this is the sense, can be used for the commission of international crimes. In other words, you can't justify the commission of genocide, war crimes, and crimes against humanity using your immunity. So before the ICC, the immunity will not, if the prosecutor decides to bring these charges, of course, will not have any relevance. Could have just relevance before courts in other contexts.
Okay, so since you've mentioned the ICC, how will the ICJ's ruling influence the ICC's course of action then?
Well, of course,
at least.
Of course, there are different bodies, and I think this is important also in the light of the confusion frequently created by media, talking about the ICJ and posting pictures of the ICC or the other way around. The ICJ, as we have said so far, has competence over state responsibility, so looking at states' conduct. The ICC has competence over individual criminal responsibility, so looked at the individuals responsible of these crimes. The ICJ is part of the UN system, so it is a UN institution. The ICC is independent also on the UN. It's not an international criminal tribunal created by the United Nations system. So formally, this is just to go back to your question. Formally, the decision by the ICJ is not binding on the International Criminal Court. But since this is a decision coming from as someone has written this day, the most important court on earth, it's, I would argue, it's highly persuasive for other international organizations, institutions, and also for the International Criminal Court. My argument is the following one. If it's plausible that a genocide is being committed, there is also a reasonable basis, which is the standard used by the court, instead of the ICC here, to start an investigation. There is also a reasonable basis to believe that the genocide the genocide as a crime is being committed in the Gaza Strip. So, in other words, it's up to the discretion of the prosecutor of the ICC to bring this charge. But after all the evidence submitted by South Africa and after the decision of the court here, I strongly believe, in my personal views here, that the prosecutor should immediately submit a request for arrest warrants or summons to appear in relation to any of the crimes allegedly committed in relation to genocide here by an Israeli political military leader.
Wow, okay. This is really eye-opening. I think I'm going to ask one more question to wrap things up. South Africa has brought a landmark case to the ICJ accusing Israel of committing genocide. Given the complexity of such cases, do you think it will take the court several years to reach a conclusion on this broader question?
Yes, the answer is yes. I mean, the length of international proceedings is not short, if I can say. So it will take some years. But this does not have to lead us to underestimate the significance. I say the historic. This is the decision. So this does not mean that this decision now, even if we have to wait for 2-3 years for the definitive assessment.
So you expect 2-3 years?
It should. I mean, normally, yes. I mean, we expect that the decision won't come before at least a couple of years.
Mm-hmm.
Of course, I hope to be wrong, but looking at the length of the international proceedings, we can just try to make this prediction. That's why provisional measures were adopted, because this was the urgent procedure. And it's important to emphasize that even if we have to wait for years, some effects, short, medium, and long-term effects of the already accepted submission by the International Court of Justice, South Africa submission, may have really some important effects on different levels. I will just mention, if you allow me, some of these effects, which can be very important. We were talking before about domestic cases on the basis of universal jurisdiction. This decision can bring more other states, domestic courts, to open cases for alleged commission of genocide. So not only in Switzerland, where it's not genocide, but also in other states. The International Criminal Court as well can be triggered now, not formally, as I said, but also other sort of consequences. Like, for instance, I'm thinking arms transfer, selling weapons to Israel. And so the responsibility now of companies, but also of states that will continue to support Israel through the sale of weapons. These states in particular, of course, first of all the US, but not only, UK, Italy, and so on, France, they could be complicit of genocide here. So there could be a complicity, in the commission of genocide now that the decision has been issued. That's why I stress that the decision is particularly important and may play a very important role at different levels, in particular in relation to third state responsibility. And I would add that in the United States, on the same date of the issuance of the decision, there was an important hearing brought by different American and Palestinian organizations for genocide against Biden, Blinken, and Austin. And I'm sure that the ICJ decision will have an impact also on these domestic proceedings. That's why, again, but I want to be repetitive, I will stress the importance of the decision itself.
Okay. Thank you so much, Dr. Mariniello. That was really, I think, eye-opening and really educating. Thank you so much again for accepting our invitation.